Robertson and Google.
Yes, Mr. Bott.
Thank you. Thank you, Mr. Court. I'd like to do three things, if I may. I'd like to first summarize some of the provisions around jurisdiction that I alluded to yesterday, very briefly, if I may. Secondly, to take you
Can you
to...
speak up a little? Remember, I'm deaf and you're softly spoken. Yep.
Yes, my lord. So, secondly, to take you to some of the correspondence which took place around the time the claim form was served or delivered, and thirdly, to say something about what the implications might be for this claim.
Well, or I hope not might be.
Are, my lord, yes. Yes.
Okay, right. Okay, off we go.
So, in terms of the rules, if I could take you, please, to Rule 10.1.
Yes.
Sorry, Mr. Bosch, would you just give me a minute? Philip, could you pop back and pick up my white?
In the short term, I will.
No, don't.
Then I will deal with.
No, fine. I have looked at the next of these.
Yes. Yeah, and we can manage without. Speaking for myself, I've just been looking at 10.
Yes, my lord. So, Rule 10.1 3, which I took your lordships to yesterday, says that a defendant must file an acknowledgement of service if they wish to dispute the court's jurisdiction.
Did you take us to it yesterday? Maybe you did, and I just wasn't listening. But anyway, yeah.
The the second rule is 10.3. Now, this says that the acknowledgement of service must be filed within 14 days of the particulars of claim, where the defendant is served with a claim form which contains the particulars of claim, or 14 days after the service of the claim form in any other case.
Yeah.
So the difficulty there...
That assumes valid service.
Well, it begs the question.
Yes.
My lord.
The rules, the whole purpose of the rules is they assume people comply with them.
Yes, my lord.
So it doesn't beg the question. That assumes, thank you, that assumes that service has been valid.
Well, what if there is a dispute about whether a service has been valid? Because, as we saw yesterday...
So, yes, what if there is a dispute about whether service is valid? That's going to be the question for us, isn't it?
Well, as we saw yesterday, jurisdiction includes, specifically, by binding Court of Appeal authority, Hodinot and Patalia, the concept of jurisdiction includes service. Because
although that wasn't in a case where acknowledgement of service hadn't been filed.
Right, but nonetheless, whether or not something has been... Disputes about service are disputes about the court's jurisdiction, because service is the process by which the defendant becomes subject to the court's jurisdiction.
But we're looking at acknowledgement of service, 10.3, the 14 days. All I'm pointing out to you is that assumes service is valid. If you read in jurisdictional disputes into every rule, you would simply drive the white book, the CPR, into the ground.
But then the question becomes, if you read service to be undisputably valid service, then how do you reconcile that with Hodinot and Patalia, which specifically say that questions of service are questions of jurisdiction?
Well, not really. I mean, Patalia doesn't add on anything on this. It's Hodinot, isn't it?
Yes.
In Hodinot, that question simply didn't arise I know they said what they said, but they didn't have this point in front of them. And that's why, in handheld, Lord Justice Nugent, as he already was, but sitting in the High Court, said that it was it was debatable, and he gave his example of what counts as of two very similar situations, but one which, as it were, degrees of invalid service.
But that's, respectfully, it's a different point. In handheld, the point was whether it has to come within Rule 11, under a Rule 11 application. And there, Lord Justice Nugent was saying that that is questionable. But handheld products never questioned the concept of service, the concept of jurisdiction and whether it includes service. To the contrary, it assumed it did.
I don't know. Isn't this the if you look at para 79, the first sentence says, "It's not obvious to me that Hodinot stands as authority for the wider proposition that if the claimant claims to have served the defendant and the defendant denies there's been any effective service, the defendant must still use Part 11 to challenge the effectiveness of service." It's possible that follows, but I don't think it necessarily follows. And then he goes on to say he doesn't have to decide the point. But the rest of the paragraph, he's explaining what the point is and gives his example of where there's been service on a neighbour. And he says the ratio in Hodinot, bottom of page 76 in the bundle, is the reasoning of Lord Justice Dyson in Hodinot is that where a defendant has acknowledged service and hasn't brought an application, consequences in 11.5 follow. That does not necessarily apply where a defendant has not acknowledged service. The logic of his judgment doesn't compel the conclusion that the defendant has not acknowledged service and only raised the issue whether service has been effected at all by using Part 11. So you're saying it's all decided by Hodinot. Lord Justice Nugent didn't think it was.
Well, what I'm saying specifically is that it was decided by Hodinot and Battaglia that jurisdiction includes issues of service.
Well, why did Mr. Justice Nugent not think so? Lord Justice Nugent, sorry.
Well, Lord Justice Nugent said that there might be situations where issues of service arise incidentally, such as a 7.73.
No. I'm not worrying about that bit. He goes on to deal. I'm worrying about what he said in para 79.
But he didn't say that issues. He said that my lord, it's a slightly different point. He said that the question whether or not Rule 11 is the sole forum for challenging jurisdiction, including service, that is an issue in circumstances where there hasn't been an acknowledgement of service. That is an issue which has not been decided, and which I'm inviting the court to decide in Mr. Robertson's favour.
Yes.
But the question as to whether jurisdictional challenges include service challenges, that has been decided.
If that was so, why doesn't it necessarily follow that they must be taken by order? They must be taken by an application under Part 11.
Well,
which Lord Justice Nugent thought it didn't follow.
Well, he says it doesn't logically follow on the argument before him. But if you this argument was not made in these terms. So if you look at at Rule 10.1, it specifically says that if you want to challenge jurisdiction, you have to file an acknowledgement of service.
I know, but the question is what is meant by jurisdiction, and your answer is, well, we don't have to consider that because we've been told in Hodinot, and it has the very wide meaning in dealt with in paras 21 to 24.
Yes.
And specifically in 22. But Hodinot was not a case where as is accepted here, there had not been any effective service at all because the requirement to serve an N510 had been ignored.
Well, I would suggest that in this case there's a dispute about valid service, and that dispute has made its way before this court. So there must be
There's
something
no
to it.
dispute about valid service, is there? What is the dispute?
Well, the dispute is the defendant says there hasn't been valid service because the claim form has expired. The claimant says there's valid service subject to obtaining permission under 6.342b, and that permission has been obtained, and therefore service is valid.
Right, but there is no dispute that the service actually as effected and as initially claimed to have been effected was not valid service. Yeah, I see it. It's in your cell as an argument.
Yes, my lord, that is correct.
I'm just seeing exactly what was said in paragraph 23. Probably not. Well, I'll hear any submissions you have to make about it, any further submission, but your broad position is that the effect of para 23 in particular, summarised in 23, is that for the purpose of actually Rule 10.1, which is more important than in 11.1, jurisdiction means any dispute about whether purported service has been effective.
Yes.
And in some respects, that sort of mirrors the competence point in arbitrations, where people dispute whether the arbitrator has jurisdiction to decide a point, but they accept that he's got competence to decide whether he's competent.
Yes, my lord.
And if you don't use CPR 11, no one knows where they are because everyone's up in the air.
It's an important policy point that I will come to in a moment, but yes, my lord, I agree with that. And so I say that in 10.3, the word service must include disputed service.
What about a situation in which the process server gives sworn evidence that they delivered it to the correct address? Let it be assumed that actually there's been a mistake. The process server delivered it next door because you got the numbers on the houses wrong. So there has never been any service. But it comes to the attention of the defendants that the claimant is claiming there was. Maybe, most obviously, because he's attempted to enter default judgment. If the defendant seeks to set aside the default judgment on the basis you've never served, does that have to be done by an application under Part 11.1?
Yes.
Is that how it's normally done? It seems to.
Not necessarily, but the point hasn't previously been decided. So in my submission, in a situation like that, the defendant, once he becomes aware of the process, if he's out of time to file an acknowledgement of service, or let's say there is an application for default judgment, he asks for more time to file an acknowledgement of service, and then he challenges jurisdiction in the proper way. Otherwise,
so let me get this right. The bailiffs turn up at his premises, flourishing a default judgment. First, he's heard about it.
yes,
And he goes off to the county court. Ages since I've done any of this, but there is a procedure for setting aside a default judgment, isn't there?
Part 13.
Part 13. Well, we needn't, if necessary, we'll look at it, but it presumably provides for an application to be made, and perhaps we better look at it, because this is really where the shoe pinches. So it's 13.4. You make an application under this part, 13.41Bs, or by various different lists. But the key point is you have to make an application under this part. So you're saying that application to set up, which is an application to set aside the default judgment, is incomplete unless and until a separate application is made under part 11 to dispute the jurisdiction of the court on the basis that there has been ineffective service.
I say that there are two possible situations. One of the situations is that the defendant simply hasn't received the claim form and is unaware of the proceedings. In such a case, whether or not there's been effective service, he should have more time to become aware of the proceedings, to serve in acknowledgement of service, and so on, and go through the normal process and decide whether or not he wants to challenge jurisdiction. The second situation is where a defendant has been served, or at least been given proceedings, and has simply decided unilaterally that this is not valid service, and then does nothing. And that creates a situation of uncertainty as to the jurisdiction of the court, which is undesirable. In a situation like that, if the defendant then 6 months later or a year later raises issues of jurisdiction, including service,
doesn't that have all sorts of unfortunate questions of degree? Suppose the process server has not put it through the letterbox, but has simply thrown it over the wall, and the defendant sees that there is a package and has a strong suspicion what it is, but never picks it up. Is that a case where there has been no service at all, or whether there is a dispute as to whether there is effective service? Because that seems to be the distinction you're making.
Yes, but all I'm saying is that that is a dispute that the court will have to decide at some point, and the rules of procedure should be followed, and the proper way of doing this is a formal statement in the acknowledgement of service by the defendant saying that he disputes service, and then a challenge under Rule 11, because that's what the rules dictate.
It's a bit odd, as Lord Justice Nugee pointed out, it's a bit odd to have to serve an acknowledgement of service where your contention is there's been no service at all. You think that he's just wrong, he hasn't understood it properly. You're allowed to say that, by the way. Judges do sometimes get it wrong.
Well, I would suggest that Lord Justice Nugee has not considered these issues in that case.
You're quite right. It doesn't purport to have resolved them, but it does seem to me that they're really quite difficult issues.
They are quite difficult issues, my lord. They are difficult issues.
Yeah.
Well, the question is...
Sorry, anyway, I don't want to waste time anymore. I've just been puzzling it out, as you can tell.
I appreciate it's a difficult position because issues of jurisdiction, issues of service are normally not perhaps thought of as issues of jurisdiction. And the position is that either Patalia and Holinod would have to be overruled on that point. Because, by the way, I want to say a little bit about Patalia. I mean, this is a case...
I've been telling you Patalia doesn't add to it, but you say it does.
Well, I would suggest that it illustrates the point, because effectively in Patalia, a claim form was served out of time, an expired claim form. And the reasoning is, the decision is that if not for the court's application, of CPR 3.10 to rectify matters, there would have been valid service, and the court would have had jurisdiction to hear the claim, in spite of the claim form being served out of time. So in this case,
Sorry, which paragraph of Patali are you referring to?
paragraph 5, my lord. So it says that
5.
yes, they served an unsealed version of the claim form, which had been amended since issue, together with particulars of claim, a schedule of loss, and a response back on 27th November.
That's the fact. Sorry, I thought you were saying there was a principle.
Well,
Because in this case, the claim was struck out
yes,
and the appeal was dismissed on the basis that the court could assist the defendant for the error of in relation to the box ticking.
yes. So they had ticked the wrong box on the acknowledgement of service.
So what's the point of principle that you rely on in Battaglia, which is the paragraph?
And may I state the point of principle, my lord, and then take you to it?
Well, I'd prefer to see it,
Yes, my lord.
because on the face of it, Battaglia is against you. So I'm keen to see why you rely on it, because I may be missing the point completely.
So, paragraph 21. This is a quotation from His Honour Judge Pearce, with which Lord Justice Bean completely agrees. He says in the final paragraph of the judgment that he wishes to pay tribute to
Yes.
Judge Pearce. And he says here,
So sorry, which paragraph we're going to?
so this is 21 of the judgment,
Yep, okay.
and within the quotation, well, actually, if I could invite the court, well, specific 61
Sorry, 61.
within the quotation, yes.
Sorry, the quotation in paragraph. Oh, I 61. Sorry, I was looking at the wrong quotation. Yes, thank you.
Actually, I'm very sorry, my lord. If I could ask you to read 58 within the quotation as well.
Yeah.
And then 61 and 63 as well, please.
Yeah.
So if I serve a claim form that is expired and the defendant files an acknowledgement of service but does not challenge jurisdiction under Rule 11, then the court has jurisdiction. Then the defendant has accepted jurisdiction, even if the claim form has expired. And so I say this is an authority.
But that wasn't the result in Patalia.
It wasn't
Because
the
in
result.
Patalia, they looked at the facts and said, well, it can't be said that they were accepting jurisdiction. And so they used 310 to assist the defendant round the short point that all they'd not done was refer expressly to CPR 11.1.
Yes, but it must follow that if the court had not decided to use 3.10, then the court would have had jurisdiction
Well,
because the defendant had followed the wrong procedure. There is a point around 310 which I propose to come back to a little bit later, my lord.
right. So does it follow that your submission for the first time on day 2 of the appeal is that that Google have always accepted, must be deemed to have always accepted jurisdiction?
No, my lord.
So that's what Hodinot and, say, for the 310 point Patalia are saying, that the defendant is assumed to have accepted jurisdiction. Presumed, deemed.
Yes. It follows that if Google had filed an acknowledgement of service, then, and not made a Rule 11 application, then they would have accepted jurisdiction.
Okay, but what about the situation where they haven't?
Yes, my lord. I will come to that. So,
Well, that's what we're all very keen to know.
Yeah. Well, we got onto this because you were on 10.1, and your point about 10.1 3b, which I think is more important to your case than 10.3, although you need both,
yes.
is that you've got to make an application about jurisdiction. Sorry. Put it more accurately, a defendant who wishes to dispute the court's jurisdiction must file an acknowledgement of service.
Yes.
And if you don't, what follows?
Right. Before I address that point, may I say something about the policy considerations that my Lord, Lord Justice Dingemans was touching upon? Thank you.
We're on tenterhooks, but still, all right. Say about policy considerations.
Thank you. So in terms of policy, I would just take you to paragraph 8 of, no need to look it up. This is Barton and Wright, a statement by Lord Sumption. He says that as a general rule, service of originating process is the act by which the defendant is subjected to the court's jurisdiction. That is a fundamental principle, and for that reason, challenges to the jurisdiction of the court, including service challenges, should be treated strictly, so the rules should be followed. That's my first proposition.
Yes, but the problem is we don't know what the rules say. Or rather, we don't. If it was clear what the answer was on the rules, that's fine, they must be followed, but we don't.
Well,
I certainly don't.
So what the rules I'm speaking about now is the rule that if you want to challenge jurisdiction, you have to do so through acknowledgement of service in Rule 11. That's what I'm alluding to. So it is important for that reason that these rules be followed strictly, because jurisdiction is such an important point, and also because it is important to be very clear in the beginning of the proceedings whether or not the court has jurisdiction, and precisely what is being challenged and what is not. And then, of course, there is the point I mentioned yesterday, which is that if you don't challenge jurisdiction this way, then you might have multiple jurisdictional challenges, because then you can challenge under Rule 11 later on a different point, potentially. That is highly undesirable. Now, what is then the position? Actually, I would like to take your lordships to just some of the correspondence to give a context for this.
Well, look, just indulge me. In a single sentence, tell me what. Seeing all the correspondence and so on doesn't help unless one knows
Yes.
what proposition you're trying to advance.
So,
We have here a situation not so far considered in the authorities.
yes.
It's though flirted with by Lord Justice Nugent in handheld,
Yes.
where a party wishing to dispute jurisdiction has not in fact filed an acknowledgement of service. In law, what are you saying is are the consequences of that failure? You needn't develop the point, but at least I then see how it's going.
Yes, my lord. So I say that there are two. Well, the first question is there a way for the court to rectify or regularize what has happened to date? That is the first
Before
question.
we get to the remedy, what is your case? What is your submission? Here there is no acknowledgement of service.
Yes.
Here there's been no reference to Rule 11.
Yes.
So what do you say about that? Before we get to remedying that or possibility of remedying that, what
So
is your case?
My submission is that either the defendant must make an application under Rule 3.10 to regularize what has happened to date, such that, like in Patalia, the
Well, don't worry, make an application under 3.10.
Yes.
Or what's the other alternative?
the other alternative is to make an application under 3.9 for an extension of time to file an acknowledgement of service.
Okay, and if they haven't done that, what is the position?
Well, the position is that the court should not have considered the jurisdiction issues, and therefore those decisions are void.
Which decisions are void?
Well, the decision of the court.
What the decision of the district judge in this case was void.
Yes, my lord.
I see. Okay.
On the issue of jurisdiction.
On the issue of jurisdiction,
Yes, both.
you mean the Equality Act point?
Well, both of them, both the service point and the
Who was
territorial.
deciding your application? And he found in your favour.
Yes.
You say that was a void decision by reference to this morning's argument.
I would say that let me put the point in a different way. I would say that those are matters which should not have been considered as a matter of procedure, and therefore, if they cannot be rectified under 3.10, then they cannot have effect.
That's just another way of saying void, isn't it? They can't have effect.
Well, if the court has done something which it ought not to have done as a matter of procedure, so if I'm right that jurisdiction challenges should be under Rule 11, and the court has done something, the court below has done something which it shouldn't have done, namely entertain a jurisdiction challenge in a different context, well, it stands to reason that the Court of Appeal should not give effect to that.
You just said, you just qualified that by reference to the jurisdiction challenge, hence my earlier question.
Yes.
I understand all of this in relation to the jurisdiction challenge, what I think of as the Equality Act point. I understand that.
Yes.
But you're saying this holds also true for your application and the judge's decision on your application for relief from sanctions. You say that's also void.
No, my lord. I'm not talking about relief from sanctions.
You are, because you said it covers everything the judge did.
No, I'm saying it covers the jurisdiction points. So that's the
So I
service
think there's a
point.
confusion about the jurisdiction point. As my lord says, there was a point which is not live before us, which the judge decided in your favour about effectively territorial jurisdiction. But you're saying jurisdiction goes wider than that in this context. You're saying, as I understand it, based on Hoddinott, that disputes about service, about whether service was effective, are also jurisdiction points.
Yes. I say that's very clear for both, from both Hodinot and Battalion.
I know you are. I know you're saying that. Okay, but what happens then when, forget the territorial jurisdiction point, what happens when there is a dispute about service, whether service has been effective, or actually, because here this is really what the dispute is, whether it's been ineffective but can be cured.
Yes.
You're saying, as I understand it, that that can only be done after an acknowledgement of service has been filed.
Yes.
And an appropriate application made, i.e. one under Part 11, though subject to the possibility of correcting it under 310, as happened in Battalion. What happens when none of that has been raised, but the court is being asked to decide, nevertheless, by your own application, whether service was effective or can be rendered effective? You're saying the whole thing was shouldn't have been entertained.
I am saying, so let me be precise. I am saying that if you do not include the form N510 with your claim form, and this has been the claimant's position from the beginning, if you do not file and serve the form N510, then that can be remedied through an application for relief from sanctions under Rule 6.34.
Yes.
But isn't that a point going to jurisdiction? Because it's a point about validity of service?
Well, it's not really a point about validity of service. It's a point about dispensing with the need to file and serve N510.
It's going to jurisdiction.
But the effect of it is that you have validity of service.
But you're going to jurisdiction because you're seeking the court's indulgence.
But it's only the challenge to the jurisdiction by the defendant, which is called by Rule 11.
Yes, I dare say, but your answer to that challenge is the application for relief from sanctions.
Yes.
If Hodinot is as wide as you keep telling us it is, that is a dispute about jurisdiction.
Yes.
You never needed to make your application for relief from sanctions. It was up to them to to acknowledge service and file the appropriate application. Isn't that your position? I'm trying to understand.
My position is that in that situation, the claimant can do one of two things. One is to make an application for relief from sanctions to obviate the need for serving the form N510. The other option is to wait for the defendant to challenge jurisdiction and make the relief from sanctions application in that context. However, if the defendant challenges jurisdiction, then it must do so under Rule 11.
Okay, let me just write this down.
Yes.
So if defendant wishes to challenge jurisdiction on the basis that N510 not served, it not filed or served, it has to do so by filing an acknowledgement of service, and making an application within 14 days. And if it does not do so, well, I'll come back to what happens if it does not do so. Well, I suppose, and if it does not do so,
then it accepts jurisdiction.
Well, it doesn't accept jurisdiction.
I'm sorry, if
What?
it doesn't, if
If it doesn't do so, you can proceed to enforce judgment. Is that right? For the failure to file an acknowledgement of service.
Yes, my lord.
At which point, if that had happened, they would have not only to apply under Part 13, but also to file an acknowledgement of service and make a Part 11 application. Because that's what Hollyknott says. Is the implication of what Hollyknott says. But then the second point is, however, that does not preclude you doing what you did in this case, preclude claimant from grasping the nettle sooner and applying for relief from sanctions.
Under 6.34.
Exactly. In which case, the question of what the defendant has to do to dispute jurisdiction does not arise, because it's your application and the court has jurisdiction to deal with it because you are not bound by CPR 10.1. Sorry, that's me thinking it out, but is that right? You're basically saying that your application isn't void, but if the defendants object to the jurisdiction, it can't be entertained unless they follow the proper route.
Yes.
Now here they're not objecting to the jurisdiction as such, they're merely resisting your application.
Well, respectfully, my lord, they are.
So are they debarred from resisting your application, are they? Because resisting your application involves disputing the jurisdiction. Is that your position?
No, my position is that the relief from sanctions application should be limited to considering issues which are normally considered in those sorts of applications.
We understand that, but just assume for the moment that the judge's instinct about your relief from sanctions application was right, and that his eventual decision was wrong, and that we conclude that the judge was right. So that the judge was right to say it was Rule 7.63, and therefore you needed an extension of time which you didn't get. Then what?
Well, then I say, the question is whether Rule 3.10 can be used to rectify.
No. Assume you've lost. You said the claimant had a choice. It either waited for the defendant or it made its own application.
Yes.
Let's assume that the claimant makes its own application and loses. Rule 3.10 doesn't come into it. Because as my lord says, all that the defendant was doing was resisting the application.
Yes. Well,
So
it does, because the question of relief from sanctions hasn't been appealed. It's the construction of Rule 6.34.
Judge's order has been appealed.
But not on the issue of whether or not relief from sanctions should have been granted.
That's the question we have to decide. We dealt with all of that yesterday.
Yeah.
Just assume
Suppose you
you
lost.
lose on that point. What I'm trying to work at is how this point can then help you. Because it sounds as if you're saying, well, even if I lose what this appeal until today was all about, somehow I still win,
Well,
which would be an extraordinary outcome. So I'm just, what happens if we were against you on your submissions yesterday?
I appreciate that there are practical aspects of what I'm submitting which are not, which do not appeal to your lordships, and I can understand why. There are practical aspects of the defendant submissions which are also.
I'm just trying to get to
yes.
what is the practical aspect.
So,
I haven't expressed a view about that because I don't know what it is yet.
so if I may just clarify an issue, my lord, with respect, there are two issues, two separate issues. One is the relief from sanctions issue, which the judge below treats separately, and these are issues of should relief from sanctions be granted because there has been no prejudice, etc. That is not under appeal. The other issue is the 7
It is, with respect, it is. That's what the appeal is all about.
The whole point is he shouldn't have been doing a relief from sanctions exercise.
You should have been seeking an extension of time under 763.
Yeah. Now, if you suppose you've lost on that, that's what we're trying to put to you, which is that's what the appeal is about. You are now saying, you said it initially in the costs context,
yes,
but we're teasing out what the implications are for the outside the costs context, if any, that quite apart from the whole 7.63, 6.34 debate on which X hypothesize you've lost, the defendant is unable to say that there was no proper service, because the only way the defendant can do that is by making an application, by filing an acknowledgement of service and making an application under 11.4. Where does that leave us in this litigation?
yes. So the defendant would have to make an application under Rule 3.10 to treat what has gone before as a Part 11 application.
But he couldn't do that. It hasn't served an acknowledgement of service.
Precisely.
So where does that leave us?
So that then is a separate question as to whether the court has the power under 3.10 to dispense with the service of an acknowledgement of service, and that is
Nobody's made any such application now. Suppose no such application is made, or it is made and we decide we have no power to do it. What is the position?
Well, what is the
position? Is I think you're saying the position is there can be no objection to the validity of your service, and logically, your relief from sanctions application was unnecessary. At any rate, unnecessary at that time because there had been no valid objection to service. Isn't that the logic of your position?
The logic of my position is that the appeal court cannot ratify a decision of the court below which is incorrect because it followed the wrong procedure. The implication of that is that this court would have to say, well, subject to an application either under Rule 3.10 or 3.9 for relief from sanctions for not filing an acknowledgement of service, etc.
All right. I think
if none of that can be established by the defendant such that it can correctly challenge the jurisdiction, then it is open for the claimant to make an application for default judgment.
Yes, well, that's what I thought you would say. Yes, right. So effectively, you're saying there's been there has at this stage been no effective challenge to the jurisdiction, unless some application is made on 3.9, 3.10, which hasn't been made yet, perhaps unsurprisingly, since the point only emerged yesterday. But assuming that isn't done or isn't available,
yes,
the simple position is that you can go ahead and send in the bailiffs and get a default judgment. And we can't probably say that on this because you haven't applied for a default judgment. So that is the implication of the point you're taking.
Yes, my lord.
Okay, thank you. Well, I think we've got there. Subject to anything either of my lords want to ask. We'll now let you take us to the correspondence if you really want to, which I think was the next thing on your agenda. Of your 3 points, we have effectively, because we wanted to know where it was going, we've effectively got your submissions on your point 3, which is implications for this claim. And you had already summarised the relevant provisions about jurisdiction.
Yes.
So all that's left, I think, is you wanted to take us to the correspondence, which you can certainly do if it helps you.
I think it might give the court some context. I will be brief and take it to 3 letters. It's in the supplementary bundle at tab 13. The first letter is page 146.
And 40.
And 46, my lord.
46. This is the M510 letter.
This is Pinson Mason's letter dated.
Yeah, this is the letter where they say you haven't served or filed N510.
Yes, my lord.
Yeah.
So they say here, this is the argument they've been making.
Sorry, I was just making a note. I'll just catch up. Which page are you on?
146.
146. Yes, thank you. Carry on.
So they say here in the third paragraph, on the basis of the above, it appears to us that your client's claim has not been served. On the basis of the argument that they
Yeah.
have made before the court. If you then turn to 149, this is my letter dated 22nd of April, and it simply says that I enclosed the N510, I've made an application, or I'm going to make an application for relief from sanctions under CPR 6.34(2)B to obviate the need to serve form N510, rendering service of the claim form, etc. effective. And then the next letter is 27th of April. This is 151. And then under the heading, no submission to jurisdiction, it says, as a preliminary matter, to be clear, nothing in this letter amounts to a submission by our client to the jurisdiction of the above proceedings. Our client's position in this regard is strictly reserved. So, in spite of having received the claim, they are not following, they're not saying that they're challenging the jurisdiction. They are saying that they're challenging service, but their
Yes, but
position.
you said service and jurisdiction are the same thing.
Yes, this is this I say is a misunderstanding by Mr. Barker of Pinson Masons, who's writing this, of course. But what they mean is territorial jurisdiction. And then the next letter I want to take you to is 166. And this is 23rd of September, so some 5 months later. And again, they say in the second paragraph, Google has not acknowledged service because the proceedings have not been properly served,
Yeah.
etc. And then again, they say that they reserve their position on the issue of jurisdiction. So I say this is a misunderstanding of the concept of jurisdiction.
Yeah. Well, okay, we see exactly which. That's all the submission you've made already. The question whether you're right about that.
Yes.
Which is what we've got to decide at some point.
And what they should have done, of course, is file an acknowledgement of service. It's undesirable to be in this position where you then get a jurisdiction challenge raised.
Well, they've taken a view about what the law is, and we've got to decide whether it's right or not.
Yes, my lord.
Right.
Can I?
Yes.
Sorry, just one point. The normal position, if you fail to serve proceedings in time, and so the court doesn't grant an extension, the normal position is that those proceedings are a nullity. It's as if they've never happened. And sometimes that's important for the claimant, because if the proceedings are a nullity, but it means that the claimant can legitimately start again because those proceedings were a nullity, and so therefore issues of res judicata don't arise. In the present case, if you should have had an extension of time, you should have applied for an extension of time, couldn't get one, and therefore the proceedings weren't validly served, that would be the end of those proceedings. They would be a nullity.
So this issue is actually dealt with in Battaglia by reference to Barton and Wright, and this is the whole discussion about Lord Sumption's comments on whether or not a claim form is like a living creature that dies after 6 months unless it's resuscitated by the court before then.
So are you agreeing?
No, so my submission on that is that because the claim form is not like a living creature that dies after 6 months, on some level...
It was never a living creature if it was never properly served. There were no proceedings.
I will look for the reference for your lordship in a moment, but the position is that if you serve an expired claim form and the defendant does not files an acknowledgement of service and does not challenge jurisdiction, then the proceedings are resuscitated effectively.
Yeah,
they are not
It's not a nullity. I mean, yes, I think the metaphor isn't helpful, but your point is an expired claim form which is not challenged in the appropriate way.
Yes.
Will thereafter be treated as effective.
Yes.
Okay. Yeah, I think that answers my lord's point. Yeah.
Would it be helpful to take your lordship to the relevant parts of Battaglia? Or
no, it was in relation to Battaglia that I asked the question, so that's fine.
And also, speaking for myself, I'm anxious to give Mr. Roberts plenty of time.
Yeah.
Any? Yeah.
My lords, good morning. My client's primary position is that this is, or ought to be, an application to amend the grounds of appeal, and it would be opposed. I'm not going to dwell on that, but I'm going to go straight to the CPR 11 point, because I think I need to deal with it head on.
We mustn't lose sight of the original costs point.
No.
That may not be, may not require very elaborate submissions.
Well, what I'm proposing in the time I have is to deal with the CPR 11 point head on, because it's obviously of some significance.
That's what we need most help on. Yes. I'm so sorry, Mr. Robert. Can we just rise for 5 minutes?
I'd forgot.
is on the one hand there's the jurisdictions, territorial jurisdictions. There seems to be a merger of two orders of the old rules, one of which deals with that aspect, the other of which deals with jurisdiction as recorded pseudonym. Service. I think service falls within the merger. It wasn't part of the sound. Maybe I should.
Yes.
It is a point. So if service is in reason. Jurisdiction can be considered. Service can be considered.
That's true.
Just said, actually, there is something to this. There is a
Yeah.
I think the first
So far as James has said there.
Rise if able.
Sorry about that, Mr. Roberts. I think time's going to be okay, but if it isn't, we'll make sure it is.
Grateful. I was saying that strictly what needs to happen is that the claimant needs to apply to amend his grounds. I'm not going to dwell on how we would respond to that. I'm going to focus on the CPR 11 point itself, assuming that it were allowed. But I do want to just draw to the court's attention 2 points. The first is what I hope is an obvious and overwhelming prejudice to my client in the timing and manner in which this ground has been,
Well,
argument has been raised.
you can take it that we think it's most unfortunate,
Yes.
but why prejudiced? If it's a good point and it's a pure point of law and you've had enough time to think about it, why are you prejudiced?
Well, the question is whether we have had enough time, because the arguments advanced as to why the entire appeal is void, I think, is the language of my opponent, was advanced this morning in the last hour. So I will be clear. I am prepared to deal with it.
Yeah, you deal with if it becomes clear to us that it's not a point we can properly deal with on this appeal, that is a course that's open to us.
Yes,
Let's see how far we get on.
This was going to be my second point, is just thinking about the wider implications of this ground or this argument.
Yes.
There are many contexts in which jurisdiction arguments are raised prior to service of the claim form or prior to acknowledgement of service. As one example, interim injunctions are often made sometimes on notice and with an undertaking by the claimant that they will file and serve their claim form of particulars of claim within a certain time. The application is heard before those steps are taken and is heard before the acknowledgement of service, therefore. It would be perverse in my submission. Let's say it's an injunction sought against someone outside the jurisdiction, someone outside England and Wales. It would be perverse if the consequence of the claimant's arguments is that the defendant can attend to argue that it's not a very good application on its merits, but can't say anything about the fact that their client is abroad because it's a jurisdiction point. My Lord, Lord Justice Underhill referred to, does this upend the default judgment provisions in the CPR? Because they have self-contained rules as to what to do. Or pre-action disclosure. It is the argument of the claimant, effectively, that in any application that arises prior to effective service of the claim form and prior to the AOS, for some reason the defendant can attend to make some arguments, but not the arguments with which the court might be most interested, which is the matter of its own jurisdiction.
I get the point entirely.
So, as I say, that is a factor as to why this point ought to be treated with caution, given the potentially wide consequences for the rest of the operation of the CPR. Now, is the point right? As I understand it, although respectfully I suggest it's something of a evolving argument, the point appears to be advanced by the claimant that a defendant who is a respondent to an on-notice application made by a claimant prior to an acknowledgement of service cannot make jurisdiction arguments. And the reliance is on CPR 10 and CPR 11 for that proposition. The essence of my point, which I hope to make good, is that CPR 11 is not and does not purport to be the only rule by which a defendant, or only means by which a defendant can object to the court's jurisdiction. We say it is part of a series of rules that sets out what steps a defendant should take upon valid service of the claim form. And I underline the word valid there. It is that these are, I'll come on to, all provisions in the CPR that are based on an assumption that we need to regulate the defendant's behaviour upon valid service of the claim. So what I propose to do is go through what I say is our statutory construction of the CPR and then go to the authorities that the claimant relies in his skeleton or supplementary skeleton.
Yes.
In terms of the structure of the CPR, it starts with the obligations of the claimant and then moves to the obligations of the defendant. So rules 6 and 7 are the obligations on the claimant to start a claim. And then rules 9, 10, 11, 14, and 15.
Hang on, 6, 7 starting claim. Yeah, 9, 10.
11, 14, and 15 are the obligations on the defendant in responding to that claim. And I say, as a matter of statutory construction, the simple point is all of those obligations are only obligations that arise upon valid service of the claim. The gateway to all those obligations is CPR 9, which is page 417 of the White Book. Rule 9.1 at the bottom, this sets out how a defendant may respond to a particulars of claim, because the duty only arises upon service of the particulars of claim. And that's in paragraph 2.
Sorry. Yeah.
And then over the page, Rule 9.2, when particulars of claim are served on a defendant, the defendant may, and then these are the things it may do. It may admit the claim under 14, it may file a defence under 15, or it may file an AOS. Now, of course, AOS is almost always produced by defendants, but they're not mandatory. It's only if you can't produce your defence within 14 days that an AOS is required, or if you contest jurisdiction. Now, the key words here are when particulars of claim are served on a defendant. So the gateway to all of the rest of these rules is the assumed valid service of the particulars of claim, and of course, therefore, the valid service of the claim form. So from that, and I propose to take your lordships to a couple of authorities, I take 2 points of principle. One, there is no obligation on a defendant to file a defence or an admission or an acknowledgement of service to a claim that has not been validly served. And two, all of the rules relied on by the claimant, i.e. rules 10 and 11, are premised on the claim having been validly served, which of course is a false premise in this case. There are a couple of authorities that make good that point. The first is Barton, the Supreme Court judgment in Barton, which I don't think we've spent much time on, and I don't propose to, but it's in the main authorities bundle.
Well, still, I by all means don't spend much time on it, but if it's important that we see it, you're going to take us to a key passage, are
I'm
you?
grateful, yes.
Yeah.
So Barton is the, no, excuse me, it's in the supplementary, claimant supplementary authorities.
Yes, it is.
Page.
Page 38, my lord.
Thank you very much. Someone else has got my bundle.
Sorry. I checked, and I've never had.
Okay.
This is Lord Sumption's judgment, paragraph 8, and it's the last sentence. Although the court may dispense with service altogether or make interlocutory orders before it has happened if necessary, as a general rule, service of originating process is the act by which the defendant is subjected to the court's jurisdiction.
Yeah.
Another smaller side point there, you see the reference to interlocutory orders, and as I gave the example of, for example, an injunction pre-service
Yes.
or pre-claim form. The other authority is Good Law Project, which is in the main authorities bundle. It's the last tab, page 554. Lady Justice Carr's judgment, paragraph 83. And it's the 5th line down, the sentence starts, it is important to emphasise again that valid service of a claim form is what founds the jurisdiction of the court over the defendant.
Sorry, I've been slow. 83, did you say?
Paragraph 83, 5 lines down, my lord.
Yeah.
So they make good, I submit, the point what my Lord Justice Coulson made to my learned friend, that effectively jurisdiction only starts over a defendant on the assumption of valid service of a claim. As to a duty to acknowledge service, that is dealt with an authority that we've sent to your clerks overnight, my Lord, and we've also provided hard copies to your
Yes, thank you. I did print it out, so no need to hand it out. In my case, it may be that I know one of my lords was actively engaged until 10:29, so may not have had it. Oh, no. Oh. So is it the Dubai one
It's
or the
the
other
Dubai
one?
one first. It's
Yeah.
Dubai Financial Group LLC in the Court of Appeal. It was a majority judgment, so I propose to take you to the two majority judgments.
Is I just looked really only at the headline. The headline, is it that Lord Justice Longmore dissented, or merely that he didn't deal with this aspect?
There was no dissent on the outcome, which was that default judgment was set aside.
Right.
It was a dissent about the operations of,
Yes, I see. Wait,
of a
the
different
majority is
rule.
obviously what
I
was
don't think there's a dissent from the principle that I'm about to take you to.
Okay, let's have a look.
So the first is at paragraph 36 of the judgment.
Yeah.
This is Lord Justice. I'm sorry, I don't think it's McComb or Macomb.
It's McComb.
McComb.
And if he were here, he would
Tell you off.
Tell me.
he wouldn't tell you off, because you very sensibly said you don't know which it is. But if you had just jumped straight into Macomb, he would have been very cross.
Well, I did ask a colleague, and I'm glad I asked the court, because I would have said the wrong pronunciation if I'd gone with what I was told. So, paragraph 36.
Yep.
Is the last sentence. At no time had failed to comply with any rule. NAS, which was the defendant, had simply not been served in accordance with the law, and time for acknowledgement of service have not begun to run against it
Yes.
at all.
Obviously, that's a point of principle. Just out of curiosity, what was the defect in service which meant that it wasn't in accordance with law in that fact of this
So
case?
what the claimant had done, had applied under Rule 6.15, that was a provision we went to yesterday,
Yes.
which provides for the court to allow a different method of service.
Yes.
And you were taken to it because that rule expressly allows for retrospective
Yes.
permission, which doesn't appear in Rule 6.334. And I believe in that case, what had happened was the court had done so, given such permission, and then held that because it allows for past retrospective service, it had deemed that valid in the past. It had held that the defendant was immediately, therefore, in default because it was long than 14 days before. So effectively, in a strike of the pen, not only did the claimant win the service
I'm
point, but
beginning
the
to regret
defendant-
having asked this question. Well, if it's important that we know, we'll have a look at exactly what happened. But the bottom line is, you rely on it for the point of principle that if you're not served in accordance with the law, then you don't have to serve an acknowledgement of service.
Yes, so the first authorities I took you were the defendant's isn't under the jurisdiction of the court, and the second is it's not under an obligation to file an AOS at
Yes,
all.
no, got it.
It's also stated in Lord Justice Tracy's judgment at paragraph 29.
And you pronounced him correctly as well.
If I might just invite your lordships to read paragraph 29.
Yeah.
So it's the first sentence effectively, which the court endorses. There's no obligation on defendants to take any steps in response to an invalidly served claim.
Yeah.
So I say effectively that's a complete answer, but I will go on to just look at CPR 10 in terms of its operation. CPR 10 wasn't referred to my learned friend skeleton argument, and was an argument I think developed for the first time today.
But I think it must be the first term or first stage in any argument based on 11.
It must be, because all CPR 11 does in terms of talking about what's mandatory is refer back to CPR 10, which is
Right.
the step
Though
here.
interestingly, as far as I can see, CPR 10 isn't explicitly referred to in Hodinot, but maybe it's there somewhere and I've missed it. Anyway, we won't get to Hodinot yet. So you're going to take to CPR 10. Yep.
I'm going to place some reliance on the editor's comments at the beginning of 10.0.1. All procedural codes have a machinery for requiring a defendant to respond to service of process and signal their intentions. So effectively, this is making good my point that these are all part of the machinery that arise, the procedural code that arises upon valid service of the claim form. In terms of the rules themselves, you can see at point 10.1 that there is strictly no requirement for an AOS. it arises either where a defendant wants more time than is the 14 days provided for in Rule 15, or if it wishes to dispute the court's jurisdiction. So, as I say, I can't really take it any further than these are all rules that are applicable upon the
Okay.
valid service.
Yeah, we got the point.
It can't be said that this rule, or Rule 11, is the only rule by which jurisdiction of the court is raised or can be made as a point. A claimant might object at some point to the jurisdiction of the court in relation to an application made by the defendant. Jurisdiction points arise all the time. They've apparently arisen today.
Well, obviously I see the structural force of what you say and the good sense of what you say, but 10(1)(3)(b), especially then read with the forward reference to Part 11, does suggest, it does appear to suggest, if you just read it literally, that that is the only way of disputing the court's jurisdiction, at least for a defendant.
It is, in my submission, it is, especially in light of Hoddenot, it is the only way if, A, the defendant wishes to dispute the jurisdiction over the claim itself, and B, upon valid service of the claim form. This is a set of rules that, that take the common rule on common law submission to jurisdiction and explain through CPR 10 and CPR 11 how a defendant is to act upon receiving a validly served claim.
But sorry, then maybe I misunderstood what you said earlier. What you were saying was that 10, read with 11, is not the only way in which an issue about the jurisdiction of the court can be raised. Let's ignore the possibility the claimant might wish to do so,
Yes.
which would be odd, but let's assume that.
That example was more in relation to an application made by a defendant rather than a claim, of
Right.
course.
To ignore the claimant's position, but I think actually that isn't what you're submitting. You have to add, but it is the only route once the defendant has been validly served.
Yes, that's the premise of my entire argument.
Yes, that's what I thought.
So do you say that 10(3)(b), do you accept Hoddenot extends jurisdiction to include issues of service or not, or you say that's wrong?
I don't think I'm in a position to. Hoddenot does.
Well, I think we'd like as much help as we can on Hoddenot. I agree Hoddenot appears, that's why my lord's gone to it. Hoddenot is a problem for your submission, elegant though it is in every other respect. So we do, if you're going to say Hoddenot is wrong or doesn't apply, wrong I agree you probably can't say if it's ratio.
I wasn't proposing to.
But I think there is an important argument about how far Hoddenot goes, as Lord Justice Newgee pointed out in Handheld.
Yes.
This is very helpful.
Yes.
But once you've set out your stall on how it ought to work, you've got to then reconcile it with the case law.
My lords, I propose to show that the case law supports our case rather than have to distinguish it or make it fit through a very small head of a needle. There is one case I want to rely on before going to the cases, which is the other case that I emailed your clerks yesterday, which is Shiblak. This is a High Court authority.
Mr. Justice Coleman, though, so someone who knew his way around.
This was a case. This is your questions, my lord, to my learned friend about default judgments are apt because this is exactly what this case was about. What had happened was.
Sorry, I just didn't hear that.
You asked my learned friend earlier the implications for default judgment of these arguments, and this case is on that point exactly.
I see. Okay.
What happened was the claimant purported to serve out of the jurisdiction in Turkey. the defendant did not acknowledge service and the claimant was successful in obtaining default judgment, the defendant then made an application to set aside that judgment on the basis that the claim form had not been validly served. And the basis was that it didn't comply with Turkish law, rules of service abroad. One of the arguments made is at paragraph 14 for the claimants. I won't say this authority takes me too far because I don't want to spoil the ending, but all that happens in this case is the judge records the claimant's arguments, which are absolutely ad idem with these arguments, and then simply doesn't answer them, and I would suggest because did not regard them as correct. But paragraph 14, the claimant said he's made the wrong application, he needs to make an application.
So sorry, paragraph 14, this is Shibboleth.
Yes. There are two paragraph 14s, my lord.
Okay,
so
which paragraph 14
it's
do I
the
want?
first paragraph 14 on page 385.
Okay, yes, I've got it, thank you.
I just invite your lordship to read the argument that was advanced by the claimant.
Yeah.
And then at paragraph 15, the development of that argument.
Yeah.
And then a response to that judgment that calls it that argument as bizarre at paragraph 20. It goes to the points I've already made. The proposition advanced.
Right, so sorry, I remember that.
Sorry, my lord. The proposition advanced on behalf of the claimant that admission to a file in prescribed, where no effective service has ever been accomplished, can be a basis for obtaining judgment in default, is one at first blush as bizarre. If I can invite your lordships to read the rest of that paragraph.
Yeah. Yes, so now is this Mr. Justice Coleman talking, or is this him responding? Is him setting out the?
It's him talking.
It's him talking.
Because his
Yeah.
conclusion at paragraph 23, it follows in my judgment.
Well, Justice Johnson says I should have known that from the language. Okay, where are we going now?
So the point I was just making before moving to the
So
claimant's
sorry, you say
authorities,
that
this argument has actually already been run.
he raises judicial eyebrows at paragraph 20, but he doesn't actually decide the point.
Well, in fact, I think, having read it, I think he does decide the point. He doesn't refer to TPR 11 again, but
Yeah.
effectively he says, well, there's no duty to file an AOS. So nothing else, the rest of it doesn't follow.
It does look to be the ratio of the decision that he's rejected the CPR 11.
My lord, yes, it's in response to the CPR 11 argument.
Is this before or after Hodnot?
This is before 2005.
It is before Hodnot.
Yes, Hodnot was heard in 2007.
Thank you.
So, in my submission, this argument has already been held by the High Court, which of course is not binding on your lordships to be a bizarre argument. So then, how do we square this with Hodnot and the other authorities?
Yes.
So, the claimant has relied on 4 authorities, only 3 of them orally. I'll just summarise my position on those authorities before going to them. 2 of them are on a point about submission to the jurisdiction, and they are Hodnot and Pitalia. They are not on point, although they contain some comment that I will rely on as being helpful. One of them, which is IMS SA, which is referred to only in writing by my learned friend, is about what happens when a defendant makes multiple CPR 11 applications. Again, we say it's not on point, but contains some helpful commentary. And the last one is handheld products, which is on point and which expressly supports the defendant's arguments. So I'll take those in turn. What I say, as I say, about Hodinot is that it's a case about submission to jurisdiction. That's the ratio of the case.
So Hodinot is a case about.
Submission to the jurisdiction. If I can, I'll just go to handheld products, which pithily summarises the law on submission to jurisdiction. So that's tab 40, the claimant's supplementary authorities.
Yeah.
Page 70.
Thank you.
My lords, there are two types of submission to the jurisdiction described in this judgment. The first is statutory submission, and the second is common law waiver. And at paragraph 63, Lord Justice Nugee, sitting in the High Court, explains that statutory submission is the operation of Rule CPR 11.
So which paragraph?
Paragraph 63.
Hang
So
on one second.
that's
Hang on 1 second.
sorry, my lord.
Yes.
And then at paragraph 64, Lord Justice Nugee sets out the various different ways in which the common law waiver test has been described. Given the time, and unless your lordships would like to go through it, I don't propose to, and I'll just make a simple point about it. I might pause and.
No, certainly no need to go through it. What's the point?
The essence is that it's not a hard edge test. It's a test that's been formulated in different ways. And I say that in practice, it results in defendants being anxious to avoid any arguments that they have accidentally submitted to the jurisdiction through their conduct.
Okay.
Now let's go, if I may, to Hodinot.
Yeah.
That's the beginning of the authorities bundle. Now, in my submission, this is a case of about statutory submission as Lord Justice described it, i.e. what happens when a defendant submits an AOS defending the claim rather than contesting it.
Yeah.
Can I just pause to be clear about a use of language for a moment, because I'm speaking to my learned leader. I'm conscious different practitioners in different areas use the language of territorial jurisdiction differently. In the context of the Equality Act, territorial jurisdiction is language typically used to describe whether the facts of the case fall within the intended scope of the legislation that Parliament intended. When you're talking about service on a defendant outside of the jurisdiction, to distinguish it, we might call it international jurisdiction, for example. But I accept that there is no universally applied term across the authorities as to what.
Well, I don't think we need to get into any of this, do we? Because there's what we've called the 13. I've called the 13.3 issue, which
Yes.
which is partly about the Equality Act and partly about the contract.
Yes.
And we're not troubled with any issue about jurisdiction of that kind, whatever label we put on it. We are concerned with jurisdiction in the form of defective service.
My lord, yes. I'm not suggesting anything turns on it. It's just that it's a point of language.
Thank you,
because
very helpful.
while the judgments refer to territorial jurisdiction, given this is an Equality Act claim,
Yes,
that is a term that has a different meaning in the context of the Equality Act, and I'll use the term international jurisdiction to describe the point that's an issue in this case. It sounds like your lordships may be very familiar by now with the judgment, but if I may, I'll just take you to some key elements of it.
Yes.
So this was a claim, amongst other things, for trespass against brought by the claimants. What I might do is describe to your lordships the facts, and I can give you the paragraph references.
Yes.
Around a week before the service deadline, the claimant applied to extend the deadline. That's paragraph 4, and applied without notice. The courts allowed the application, and the claim. Upon it allowing the application, the claimant informally sent the claim form to the defendant, put it on notice, but not formally served the claim form. And that's paragraph 10. Upon that informal notice, and therefore the defendant being aware of the litigation, the defendant made an application to set aside, and that's referred to at paragraph 11. This is prior to valid service of the claim form. There's one small point I want to make here, which is there is no suggestion here or in my submission in anywhere else in the judgment that this was an invalid application. What the judgment finds is that the application was subsequently invalidated by subsequent steps that the defendant took. That's why it's a submission to jurisdiction case.
Yeah. But
it is not a suggestion that the defendant had no jurisdictional power to make the application at all. What then happened is the claimant then validly served the claim form, because at this time he still has the court's permission to extend service. The defendant's under an obligation to enter an AOS, and when it did so, at paragraph 12, it ticked the box saying, I intend to defend the claim, and it did not tick the box contesting the jurisdiction, and it did not make any subsequent application.
Yeah.
And what?
Though of the 2 points, just to show off that I've read it, the tick box point isn't regarded as decisive. It's the failure to make it out. Oh, sorry, it's because that's Pitalia.
That's Pitalia that makes that.
Okay.
Yes.
Yep. Sorry. Yeah.
It was the failure to make any application under CPR 11, and then you have the passages which I'm not going to seek to persuade the court are wrongly decided.
There's no reference though in the relevant CPR provisions to CPR Rule 10.
No.
Yeah. Okay, which of the passages you're not to say are wrongly decided?
Paragraphs 22 and 23, where the court says this
All
is
right,
not...
you may not say they're wrongly decided, but can we just see exactly how far they go?
Yes.
It's really 20, it's not. It's really 22 is just ground clearing. It's 23.
Yes.
So the ratio in this bit is that CPR 11(1)(b) which is a form of dispute of the jurisdiction, though not, is engaged where the claim form has not been served in time.
Yes, the court here is grappling with an argument made by defendant's counsel that this is not a jurisdiction point at all. And the court said, well, actually 11(1)(a) provides for 2 types of jurisdictional issue, effectively hard-edged, the court has no discretion, and then also a discretionary decision about whether to exercise its jurisdiction. And the court is saying that whether to accept a claim form or whether to allow service of a claim form effectively is a question that is engaged under 11(1)(b). And so
Thank you. Yeah.
I'm not in a position, I don't think it obtains any of my arguments to say that's correctly decided. What is the important point then is what's concluded from paragraphs 26 and 27 is upon the defendant having entered an acknowledgement of service, purporting to defend the claim, and not making an application, then paragraph 5 of Rule 11 bites. The defendant is treated as having submitted to the jurisdiction. The key ratio is at paragraph 29. It follows
that's the key ratio, but that's the key ratio on the second issue. But you only get there if you find that a dispute about valid service engages Article 11.
Well, in this case, there was no dispute about the valid service at the time. The court had given permission to serve the claim. It had extended the time. The claimant served it within that extended time. At that time, it had been validly served. The defendant was under an obligation to enter an AOS, and it did. So the key issue the court was concerned with against that background, which is of course very different from our background, is, well, what do we do about the operation of 11.5? And the answer is, well, the defendant has subsequently accepted the jurisdiction of the court. There is a passage at 29 which I say, because it's not on point, won't answer the point, but does slightly help. Paragraph 29, it follows that since both of the conditions were satisfied, the defendant is treated as having accepted the court should exercise its jurisdiction, notwithstanding the late service. The effect of paragraph 5 was that it was to be treated as having abandoned its application to set aside the order. So there's no suggestion, as I say, that the original application was invalid. The suggestion is it was invalidated or it was abandoned by subsequent steps that the defendant took. And that's why I say Hoddenot is a submission to jurisdiction case. And that is the essential point of the case. If the claim form has not been validly served, and it has never been disputed in this case that the claim form was not validly served, then none of this ratio applies. My Lord Pitalia, which I think your Lordship...
Just hang on 1 second.
Of course.
So none of this ratio applies in a case where, a case like this, where what?
Well,
I just didn't get your. Don't need
well,
to
where two things have not happened. First, valid service of the claim form. And second, acknowledgement of service by the defendant submitting to the jurisdiction.
But why is an invalid service because the N510 isn't served, but which is capable of being subsequently subject to the other points in the case, capable of being subsequently cured by relief from sanctions? Why is that difference in kind from Hoddenot, which is a case where it was likewise invalid for a different reason, namely it was out of time, but capable of being cured by a retrospective extension?
Well, it wasn't invalid in Hoddenot. The court had granted an extension of time and it was validly served within that extension. The defendant was applying to set aside the without notice order the court had made. So we're not in that territory. We're also not in that territory because in that case, the defendant had entered an AOS defending the claim.
Well, that's a different point, yeah.
Yes. The other point I would make is I appreciate that the claimant says this is all to be determined under normal relief from sanctions rules, but it's not a relief from sanction application. It's an application seeking permission to serve the claim form. So it is, as the, we can argue about the semantics of it.
That's an important distinction, but doesn't undermine the point I was putting to you. But your answer to the point I was putting to you was that it was valid when served because of the court's order.
Yes.
Yeah. Thank you.
Pitalia,
okay, Pitalia, yeah.
I don't think I need to spend much time on Pitalia because really, I think I might cut through Pitalia by simply saying that the court was keen not to elevate form over substance.
It doesn't add much. It takes Hoddenot as read. There's a hint that Lord Justice Bean doesn't like it very much. But says that on the particular problem in that case was curable by treating an application which wasn't ostensibly made under Part 11 as being made under Part 11.
My lord, yes. It doesn't take the claimant any further, certainly. And the only point I really then take from it is that it shows effectively an attitude from the court not to elevate form over substance, where the defendant repeatedly and clearly objects to the court's jurisdiction.
But why did they then have to go through extending time in Italia?
Because the defendant had entered an AOS purporting to defend the claim and had not made an application under CPR 11. So CPR 11, having entered the AOS,
So
we know from handheld is once you've entered an AOS, the CPR bites on that AOS.
Yeah.
And we know that's a submission to the jurisdiction point. So it's the exact same point that was in Hodinot. The claimant was saying, well, you've ticked the box saying I defend the claim. You haven't made an application under CPR 11. You've submitted to the jurisdiction. And the question for the Court of Appeal in Italia was, have they submitted to the jurisdiction? And the answer was no, they have not. They have clearly been opposing it. And we can read their conduct in a way that's compliant with CPR 11.
And in Hodnot, no one argued that to treat that as an extension, as it were.
No, it wasn't a point taken. And there was a difference also because what the Court of Appeal said in Italia, that there's a timing of applications. It might seem arbitrary, but it was important in Italia. In Hodinot, the application had been made prior to the acknowledgement of service, whereas in Italia, the application that the defendant made under the wrong name, but still contesting the service, was made with the acknowledgement of service. So there was a timing point that saved the case effectively. That's why they were distinguished in their lordship's decision. The third case relied on, if I may, I'll move on to the next case.
Yeah.
It is IMS-SA, which is the last tab of the claimant's supplementary authorities. Tab 5, page 80. A High Court decision of Mr. Justice Popplewell. What happened in this case is that the claim was, so this was an international jurisdiction case. It was about valid service outside the jurisdiction. I should be clear, by the way, the first two authorities were not. I'll wait for you to...
No, sorry, I can catch up. Yep.
What the defendant did was make a CPR, acknowledged service, and made a CPR 11 application contesting jurisdiction. And it contested jurisdiction on the basis that the gateways had not been met under Rule 6 for a service out of the jurisdiction. It lost that application. Upon doing so, the court ordered it to file a new AOS. And in doing so, it contested jurisdiction again, this time on forum non-convenience grounds, so on discretionary grounds. And the question for the court in that case was whether the defendant could make two subsequent or consequent CPR 11 applications. And the question the court had to deal with is framed at paragraph 30 of the judgment. So capital is the defendant. The defendant's application is not a repetition of its first challenge. It has a different juridical basis. Nevertheless, paragraph 31, the current challenge could have been made in the alternative at the same time. So it remains to be considered whether they should be allowed to do so. Paragraph 35. Mr. Justice Popplewell said, this unitary code for jurisdiction challenges of both types suggests that where both types exist as alternatives, they should be made in a single application. There's no procedure for sequential applications in which you can try once and try again. Now, that's the context for the unitary code language that my learned friend has relied on in his supplementary skeleton argument. It is addressing a completely different point.
Okay.
The only other point I want to take from IMS is paragraph 40. One of the reasons the court ultimately refused the defendant's second application is described in the first sentence of paragraph 40. that it was potentially an abusive process to having had the opportunity to object to jurisdiction and not having taken it, to try again. Now, that's a point, my lord. I'm not saying that we would have been abuse territory necessarily, but the point is that that is an example of, if we as a defendant are met with an application by a claimant where we see the application and say, the court has no jurisdiction to make this order. If we could have run it then, didn't run it, sat on our hands and let it be decided on some other point, and then subsequently ran it, we might be open to an argument by the claimant that it was an abusive process.
Okay.
It might be quite odd, for example, in this case, if we had gone all the way up to the Court of Appeal on the CPR 7.6 point, and we had never mentioned that, in fact, we think there's no jurisdiction at all. And what a waste of time and money of everyone's if, in fact, we had a knockout jurisdiction argument. So then the final authority, my lords, is handheld products, the judgments of Lord Justice Nugee. In this case, this was another international jurisdiction case contesting service of the claim form. The claim was issued on the 29th of September. That's paragraph 8.
Page.
Page 51 is where the judgment starts, my lord. Paragraph 8 is page 53.
Thank you very much.
Paragraph 11, what the defendant then did is serve a Rule 7.7 notice on the claimant. I'm sure your lords, my lordships, your lords will be familiar with the 7.7 notice, but the effect of it is that if a claim form is not being served, the defendant can compel service by requiring it under Rule 7.7. And 7.7(3) provides that if the claimant does not do so within the specified time, the claimant may make an application to dismiss the claim. So it provides within it the defendant a right to make an application prior to service to have the claim dismissed for failing to serve the claim form. And that's what the defendant did, notwithstanding that it was based abroad and said that there was no jurisdiction over it. Paragraph...
Sorry, I was just noting something else. What the defendant did?
The defendant served a Rule 7.7 notice requiring service of the claim form.
Right.
You were saying notwithstanding that it was based abroad.
Yes, notwithstanding it was based abroad.
Okay.
Because that ends up being a point.
So the question of service had never arisen, so there'd been no attempt to serve.
My lord, no.
Yeah.
The claimant then did purport to serve by the deadline set by the defendant at paragraph 13. Now the issue is the defendant said that isn't effective service because you can't serve on us in the United Kingdom. You can't serve at the Bourne End office. And so the defendant made an application at Rule 14 under Rule 7.73 for dismissal of the claim for failing to comply with its requirement that the claimant serve the claim form. My lord, I'm conscious I'm cantering through in light of the time.
No,
I
got
hope
it so
you're with
far.
me so far, yes. So then the key question is, well, was that valid service? And after a lot of consideration, the conclusion at paragraph 59, page 69 of the bundle, is that no, it wasn't.
Yep.
So subject to the subsequent arguments about CPR 11 that the claimant raised, that was the end of it. The defendant was entitled to have the claim dismissed under its application. And you can see that the claimant's counsel raised an argument similar to that was raised in Shiblack, but this time post-Hodinot, to the effect that the defendant raised two arguments, firstly. The first is that the Rule 7.7 notice itself was a submission to the jurisdiction.
Unattractive.
And Lord Justice Nugee held it unattractive. That's when we see the case law on submissions to jurisdictions, which I've already taken the court. The only point I want to make is in his conclusions at paragraph 65. Without going through all of it, the point that Lord Justice Nugent raised is that the defendant has at every opportunity vigorously protested that it is not submitting to the jurisdiction. That's about 7 lines up from the bottom of paragraph 75. So that argument was not accepted. And the second argument is at paragraph 70, which is the point raised by my learned friend. There's only one way you can have this claim dismissed, and it's under CPR 11. Paragraph 72, the claimant's counsel took the court to the exact same passage in the white book that my learned friend has taken you to in reliance on Hodnott in support of that position. The key conclusions begin at paragraph 77 of the judgment. You were invited to read these yesterday, but they are very important. So if I might invite the court to read 77 through to 80 again, because all I will be saying is I agree.
Well, speak for myself, having seen it yesterday and
Yes.
read it again this morning.
There is a point there that supports the submission I made very much earlier, which is Lord Justice Nugent describes it as a bit odd for a defendant to acknowledge service where the contention is there's no service
Yes.
at all. I don't know if he had the authorities to which I've taken your lordships earlier this morning, but I say that it's not just a bit odd. In fact, it's simply not required, as the authorities make clear.
Yeah.
And then obviously I'm slightly begrudging that this is all described by Lord Justice Nugent as obiter in the end, but in the event it's not binding on this court, so I'll say it's persuasive regardless. But what Lord Justice Nugent then said is, well, I don't need to decide these issues because this is all about CPR 7.7. It's an application of the CPR 7. It's its own rule, and I'm going to decide it on its own terms.
Yeah.
And that, if the court wants to cut through all of this, is an answer to the current situation. This is an application under 6.34. It is not our application at all. It is for the court to determine that. That handheld products was about valid service of the claim. That was the only issue. That was one of the issues in 6.34. And so there is another way to cut through it, which is to say I don't need to deal with this because I can just answer this question under Rule 6.34, excuse me, and in this case under Rule 7.7. That's the conclusion at paragraph 82 of his judgment.
So, if I've understood that submission correctly, you say that you could read, for our case, paragraph 82 of handheld. You say you could read that, whatever the issues. It seems to me that it must be open to the court to resolve it on the hearing of the application under CPR Rule 6.34(2)(b).
My lord, yes. I will admit to being a little confused as to how, if the claimant was arguing it's impossible for the defendant to make the application because of Hodnott, his lordship considered that his observations were obiter only, but in any event, all of this is only persuasive to this court, so it doesn't really matter whether it's obiter or not.
You're being very intellectually honest and saying you're not actually sure that Lord Justice Nugent's shortcut really works. Is that what you're saying?
Well, I'm saying I have to admit it's hard to read without elevating the obiter comments to ratio, but But
Yes, right.
Well, that was probably because he was aware that he was sitting in first instance.
Yes, but you're sorry. I'm not going to make you develop a point which is
and to be
against it,
clear,
but
Lord, nowhere.
maybe this doesn't work unless he has in fact rejected Mr. de St. Ville's submission, his Matt Wilde's submission. I'm not sure that the sidestepping of it really works. That's your point. That's your.
That might be one argument, but ultimately, given the status of the judgment, all of these I'm just putting before the court as persuasive arguments.
Yeah, of course.
Can I then just address what the claimant says are effectively his policy arguments as to why, in his skeleton argument, I have now surveyed the provisions and I have surveyed the case law.
Yeah,
and I don't need to summarise my conclusions from that. Can I just briefly touch on what the claimant says are his policy arguments for preferring what I might say is not an entirely clear test, and that will require the court to turn up his supplementary skeleton argument.
Yeah.
At paragraph 10 on page 4 of the document. So the first argument is allowing for jurisdiction challenges in any other way would create uncertainty and chaos. Given there's no examples of that uncertainty and chaos, I don't need to say anything more, I don't think, other than to comment that in Patalia and Houndheld, they were both cases in which jurisdiction arguments were raised without applying under CPR 11 and without any suggestion of uncertainty and chaos. I should have said, my lord, that there was one passage in Patalia that was only helpful because in my submission it accurately described the ratio of Hodnot, and I'll just see if I can find it.
Yes.
Paragraph 33. I'm sorry to move you around.
No, I remember noticing that as well. Went through.
So,
as we were.
33, which?
Of Patalia, which is tab 2.
Yeah, no, I've got the
page 31.
31.
Page 30.
Yep.
And it's this first sentence of paragraph 33. That I say that's an accurate description of the ratio of Hodnot.
Right, going back to the policy.
Sorry, that's a complete diversion there. But the
no, it's allowed.
The second point the claimant makes is he says that the defendant can avoid the time limits under Rule 11 if it can make jurisdiction arguments prior to the acknowledgement of service. In my submission, that's completely wrong. The time limits under Rule 11 apply from the date of the acknowledgement of service. In this case, all we are talking about is applications made or heard prior to the acknowledgement of service. This is not a case where my client has made an application more than 14 days after the acknowledgement of service. Yeah. I say point C is a point that really repeats his arguments on the cost appeal, which I'll come on to shortly. And then point D is just a point about whether the claimant is properly notified of the basis of the challenge. Well, of course, there's never been a case argued a point of appeal that the claimant suffered an unfair hearing. The notice that the defendant gets of the claimant's position is the form N510, which is literally a ticking of the box. So there is no requirement that the defendant elaborate and develop a long skeleton argument with its application under CPR 11. What the defendant needs to do is say, we say you don't have jurisdiction, and then usually that's developed in a skeleton argument. I can take your lordships to the references, but way before the hearing in this case, my client, both in a skeleton argument I produced for the first hearing that was abortive, and in the witness evidence of my client, made clear we are opposing jurisdiction because we don't think the 6.33 gateway is engaged. These are fair hearing issues rather than points of principle as to how you make an application. So now
It really is on the new point, isn't it?
I'm sorry, my lord.
That's really it on the new point.
That's it on the new point. So unless I can assist you further, they are everything I want to say about CPR and 10 and 11. I hadn't anticipated that my cost arguments would be. I thought I was here today to make arguments about costs, and I will do so
Well,
succinctly.
you've risen to the challenge. I mean, yes, okay. There is. We mustn't lose sight of a straightforward cross point, which I think is really this, isn't it? That it was wrong in principle when a great chunk of the argument was taken up by the judge on a jurisdiction point. In the that kind of jurisdiction point, international jurisdiction point, on which you lost.
Yes.
For you nevertheless to get your costs because of the happenstance that it was done in the context of an application for relief from sanctions.
Yes.
And that's really true. That's really a good point, irrespective of questions about what other route there might have been for taking it. What's the answer to it?
Well, we say it's a threefold answer. The first point is, in this case, what the claimant is describing, which is he effectively formulates did our arguments have any connection with his application? That's the way he puts the appeal.
Yes.
That there is no reason to insert that gloss onto the principle already described in Swivel. The principle described in Swivel. The case
Swivel
of
is,
Swivel.
I mean, with all respect, Mr. Justice Marcus Smith, it's not a binding principle of law. It's just a common sense proposition that generally, if you win on, if you had to get everyone into court for to seek relief from sanctions, even if you get relief and they were opposed, it's all down to you, and therefore you can pay the costs.
My lord, yes.
And so I don't think saying this point doesn't derive from Swivel really matters, does it? It's more a point of general common sense.
Yes. Well, what I say is that common sense is accurately described with the following proposition. The proposition is this: the defaulting party will pay the other side's costs where the other side has behaved reasonably in response to the default. That's the sort of general approach, subject to every fact of the case, but that is the principle. And I say that general point is well capable of answering an objection by a claimant that the defendant has opportunistically taken his application to run as a vehicle for its own application or for a different argument. That's all. There's no need to add a gloss as the claimant's no connection gloss.
Yeah.
It's simply a species of unreasonable behaviour or opportunism as described in Swivel.
Can I just ask you about unreasonable behaviour? Because plainly it was a reasonable point to take, but you lost on it. And actually it had nothing to do with the reliefs and sanctions. And if you brought a claim and wasted a couple of days on a point you'd lost on, I'd only give you 80% of the cost. Why shouldn't the same apply on relief from sanctions?
So the 2 points is this, my lord. I don't accept that I'm sorry, I've already forgotten the exact wording you used, that our point had nothing to do with the relief from sanctions application. This is a point of language. It was not strictly a relief from sanctions application under 3.9. It was an application for permission to serve his claim form. If the defendant is of the view that the court has no jurisdiction to do that, that effectively the claimant is inviting the court to do something in relation to which there's no jurisdiction because the N510 can't be relied upon at all, that does have a very strong connection with the application. Yes, we lost on it, but it doesn't change the fact that it is a point that is closely connected with the application that the claimant was making.
Why is it closely connected?
Because
he's asking for relief from sanction from his default.
Well, he's asking for permission to serve his claim form without the N510. That's what That's strictly what he's asking the court to do.
Yes.
And we say, you can't serve the claim form at all because there's no jurisdiction to do so.
All right.
And this is the point.
But
This-
that doesn't leave. That doesn't answer my lord's point. Well, it may be a connected issue in that sense, but it's nevertheless substantively self-contained, and you lost on it.
That is true for a number of arguments that are raised in court. I might say this appeal should win or lose for 4 different reasons, and I might win on one of them and lose on the other 3. It is ultimately, this comes to one of the reasons I say this court should not interfere. These are matters for assessments at first instance as to how to measure that. You might think it's grossly unfair that you spent all afternoon arguing a point that you won and still you're the loser in terms of costs. But they are decisions made day in, day out in the county court and in the high court. They are matters of discretion that are not to be interfered with if the judge has correctly self-directed himself. And I don't think there's any question that the judge failed to self-direct.
So I don't know whether this is going to be one of your second submissions, but effectively you're saying is what weight to give to the fact that the overall winner lost on a particular major point. Sorry, it's not, of course, this isn't quite that situation, but
It's analogous to those.
it's analogous, is quintessentially discretionary, and no rule that you have to. Is this the same point or slightly different point? No rule that you have to divide up the costs by reference to the particular points on which people won and lost.
My lord, yes. And that is ultimately what we say the claimant's appeal is dressing up a challenge to the justice's discretion as a point. And the way that the claimant has tried to frame it as a point is he says, well, there should be a test, a no connection test. Did the other party make an argument that would have no connection to the application? And our reply to that appeal is threefold. I will repeat myself, but it is the essence of our case. The first is, and I'm taking them out of order in my skeleton, but they are clearly headed in our skeleton. The first is, you are actually just describing something that case law has already accepted, which is there's a general approach, which is the defaulting party pays, except for unreasonable behaviour, and you're describing a species of unreasonable behaviour. We don't need extra tests or extra gloss. The second is, if your test is, did our arguments have any connection with the application? Our answer is, they had firm connection. And that is the point that has now evolved into the CPR 11 point, because what we say in our skeleton is, if we were sat in front of the court, and in fact the court's about to make a ruling we say it has no jurisdiction to do, we might be open, A, to arguments that we've acceded to the court's jurisdiction, having had the opportunity to prevent the court from doing it, and not having stopped the court from doing it, by way of common law waiver. And or we might be open to abuse of process arguments, which is that we spent an awful lot of time on a point about service, when in fact we had a knockout blow. So our second point is, even if you do add this gloss of no connection, we meet that gloss.
Yeah.
But the third point is, in truth, this is just the judge self-directed himself appropriately. The judge referred himself to the conduct of the claimant and the conduct of the defendant. He said, I think the defendant has acted entirely appropriately in the way it's conducted the litigation and in responding to the claimant's default. And I awarded its costs. This court might think that was harsh. It might think that it would have decided the point differently. But it doesn't change the fact that that is, using my lord's adjective, quintessentially the role of at first instance.
I mean, I haven't caught up. I expect both my lords, but certainly Lord Justice Coulson is very on top of all this because of his previous roles. But there have been changes of fashion over the years, and about the extent to which you knock off points for losing on particular points if you are the overall winner, or the party who would otherwise have to who would otherwise be entitled to their costs. and certainly in the early days, there are quite often cases saying that's very much a secondary consideration. It's only when there's a large, discrete, quantifiable chunk of the argument
Yes.
to which costs can easily be separate costs can easily be attributable.
I accept that. I accept particularly in long-running disputes, a trial of 40 days where the costs have run into the hundreds, tens of millions, hundreds be ambitious.
This was a one-day hearing in front of the district judge?
One day hearing in front of, at the time, a deputy district judge,
Yeah.
now a circuit judge, but at the time a deputy district judge. Costs determined summarily on the standard basis. I haven't troubled your lordships with the first ground, which is the reasons challenge. If I may make 2 points about that. The first is, I won't take your lordships to the authorities, we refer them to our skeleton, but English and Emery makes clear that on cost appeals, as long as the reasons for the judge's conclusions are clear from the circumstances, you may not even require reasons at all.
Yeah.
In that case, the judge, both parties have submitted inverted commas detailed written submissions, and the judge gave no reasons at all for his decision to make no order as to costs.
In it here, there were submissions, and Mr. Ross took us to his submissions yesterday in writing. Were those? Did the judge then deal with the consequentials in writing without a hearing?
He did, my lord. That was agreed, an agreed approach between the parties.
Yes. So this is a question of him looking at the written submissions and then doing his short ruling.
Yes, in the time I won't go back to the judgment unless you'd like me to, but he expressly refers to the detailed written submissions of Mr. Bosch.
Yeah.
In my submission, he absolutely accurately describes the essence of those submissions, which is that Mr. Bosch was saying this was an inverted commas special case because of the the defendant's arguments about jurisdiction, and he didn't think this was a special case. He makes quite a lot of comments. It might be worth, if in my final act, to just take you to his comments, and then
This is the judge's comment, sorry.
these are the judge's comments in the core bundle.
Well, just give us the references.
Yes. So he makes
Well, maybe quicker and take us through.
CD 84 and 85.
yes. The reason I'm pausing is they refer back to reasons in the original judgment as well, which your lordships
We
are
can
wanting
do that.
about.
We can
Yes.
do we can do that for
So
ourselves.
if I'm just finding the references for that.
Can I just ask one question on his reasons?
My lord, yeah.
Because he does say, they acted appropriately and that's, can't be gainsaid, and that it was a reasonable point to take. But that's not the entire test when you're deciding whether or not you've taken up a lot of the time and you've lost on a point, and frankly there should be a percentage reduction.
Yes, I mean,
because it's quite reasonable to take a lot of the points that then lose, and only fair to both parties to reflect it. And the judge has only directed himself, was this reasonable to do? Which he answered it was.
He was answering the claimant's submission. The claimant was not saying we should make some sort of the normal principles where the losing party says, well, I won on these arguments and therefore I should get my costs of winning. What the claimant was saying was, submitting to the judge, there's a general rule, he describes it in those terms, but I want you to depart from it because we're a special case, because what the defendant was arguing had no connection with our application. And the judge, in his comments on that point, have to be seen as a response to what the claimant was arguing and rejecting those arguments. I accept he then didn't go on to say, well, we spent 4 hours on this argument, 3 hours on that argument, but he wasn't invited, and that wasn't the basis of the claimant's argument, to do that apportionment. He was invited to deal with the discrete point of whether the defendant's conduct amounted to something that had no connection with the application. And he went quite far in his conclusions. So, yes, there at paragraph 7 of his judgment on page 84 of the core bundle. And, my lord, the reference to his criticism of the claimant's conduct in the original judgment is page 77, paragraph 61. I've given my learned friend about 6 minutes in reply.
Well, I think we are going to give him a little more, but not much. but I think in the circumstances where a new point has been taken, which had to be gone through, there's no criticism of the time you've taken. Thank you very much, Mr. Roberts. Mr. Bott, we've been over the ground pretty thoroughly, both in your submissions and in your submissions. We know your case pretty well, so I must ask you to confine yourself to pure reply points rather than repetition points. We won't rise promptly at 1, but we will not give you much. Sorry, is that right? But we will not give you much after. So be economical.
Well, perhaps I will do so, my lord. Firstly, in terms of other contexts for raising jurisdiction issues, the difficulty with my learned friend's submission is that he's not talking about the context of the rules. So he says applications prior to proceedings being issued, as an example. Well, that's not within Rule 10 or Rule 11, so that simply doesn't arise. I'm not saying that that is. I'm saying that the only forum within which the defendant can challenge jurisdiction is Rule 11 upon being served with the claim form. I'll come back to the issue of service.
Okay, got that point.
The second point is that the White Book uses the word served, and the crux of the issue, of course, is that whether or not this has to be valid service. And I say that my learned friend here misses the point, because yes, it has to be valid service, but what if there is a dispute about whether or not that is valid service? Then that raises the question, how is this dispute resolved? By what means? And I say that dispute can only be resolved under Rule 11 in this context.
Yeah.
The two cases quoted do not assist my learned friend for the same reasons, I say. Especially the second one, where the point, the Turkish case, Şilek, the point wasn't really properly considered. So with the Dubai Finance case, you need not do anything if there is no valid service. Well, what if there is valid service? What if there is a dispute about whether it's valid? Then you do need to do something, I say.
So that comes back to your essential point which you just made.
Yes.
Yeah. Okay.
In terms of IMS, if I could just take your lordships to paragraph 27. I don't propose that your lordships read it now because of the time, but perhaps if you could make a note to come back to it.
Well, what's the point you're making? I mean, we'd happily read 27, but the truth is this is only a first instance decision. Mr. Roberts wasn't himself relying on it. He was merely saying it didn't help you. We spent about 1 minute on it. So
yes, my lord. So the point is that Mr. Justice Popplewell here touches upon the genesis, if you like, of Rule 11. There is more commentary on this in the White Book. The short point is that the issue that challenges to service come within Rule 11 is not just a matter of reading the Hodinot decision. It's an issue that goes much deeper and has its genesis at the time that Rule 11 was formulated, when two orders of the Supreme Court, the old rules, were merged.
okay. Okay, so that's your point on the cases. That's your argument on the cases, or is there more to say on those?
On Patalia, the point I want to emphasize was that the court had to apply Rule 3.10 because without that, the jurisdiction would not have been validly challenged. But that's a repetition of my point.
Yeah.
Just in terms of sort of the overarching argument before I get to the costs issues, the overarching argument around Rule 11 is kind of a Denton and White point, that it is important that litigants follow the CPR and that you don't have this free-for-all where challenges to jurisdiction can be raised in other contexts. And the CPR is very clear that these challenges should be under Rule 11, I say.
Yeah.
Unless your lordships have any questions on this, I propose to discuss the cost
Yeah,
issues briefly.
Thank you. That's very helpful.
I could spend much more time on it, but so on the costs issues, there are 3 points. One point is, the first point is that it's not connected in the way that the defendant says it is. So the territorial jurisdiction point it's a question essentially of a dispute about which box was ticked on the N510. And that is a dispute which would have been brought in any event. It did not need to be brought within the relief from sanction or the 6.34 application. On the point of discretion, well, just basically on the point of quantum, I would say that this is a £50,000 costs bill at the end of a one-day application. There have been prior hearings as well, which had been aborted. There had been a silken
deals with all of that in his judgment. That's
Yes,
what the
that's
point
why
of
you got it also. You got a pretty hefty discount in terms of summary assessment, no doubt rightly. And but the only point about quantum is effectively the point that we were putting to Mr. Roberts, which was that should the judge, whatever the position is about connected or not connected, have reflected the fact that a chunk of the day's argument was taken up on a point on which a self-contained point on which they lost.
Yes.
And he says, broad matter for the judge's discretion. Anyway, that wasn't the argument that was really being put. You were putting your connected argument. You weren't saying, well, we spent, 4 hours on this point and only 1 on the other, or whatever it might be.
Yes, it had nothing to do with conduct. It had nothing to do with accusations of unreasonable behavior. This is a mischaracterization of the claimant's arguments. In terms of the quantum point, I just want to say that it's in response to my learned friend's point. This is not a normal run of the mill relief from sanctions application. The judge decided the matter by reference to Swivel, and I say that he should not have done so.
Yeah. That may be it.
Thank you, my lord.
Thank you to all counsel and those behind you for arguments which have turned out to be much wider ranging than may have seemed at first sight. We will, of course, be reserving our decision, and you may not get it quite as quickly as you otherwise would given the imminence of the vacation. I hope you'll still get it in the course of the vacation. You will be aware, of course, but it's important nevertheless that I emphasise that when judgments are circulated in draft, as they will be, that is only for the very limited purposes identified in the Counsel General for Wales case, and should only be circulated to the client, obviously, but more importantly to anyone else, for the very limited purposes of which are identified in the Counsel General for Wales case, and any further circulation for any other purpose may be a contempt of court. Thank you all very much.
All right.